guest tonight is here to talk about a case which is as compelling as it is mystifying. It was on the morning of the 14th of February 2013 that 4 shots rang out from the gun of Oscar Pistorius, a Paralympic athlete and rising star in his country and around the world. 3 of those shots hit the 29-year-old South African model, Reeva Steenkamp. She died not long after a fatal wound to her head. What led up to her death and the reasons for her killing are now being examined by a judge. There is no jury in a court in Pretoria, South Africa. To talk us through the main elements of the case and some of the legal subtleties is the esteemed criminal lawyer and special legal advisor to Sky News over there in South Africa, Dr. Llewelyn Curlewis. Thanks for joining me this evening, Llewelyn.
Good evening, and it's a pleasure to join you.
I think one of the reasons that I've been able to follow this case, and I suppose maintain an interest, is because it's not very technical. It's quite simple to follow.
Correct. From a legal perspective, and talking as a practitioner myself that is doing this every day of my life, this is not supposed to be one of the most difficult cases out there. But nothing special about it. It's a straightforward case of murder. In terms of our law, we have a competent verdict, obviously, on the main charge, which is murder, and we call it culpable homicide, which require a lesser degree of guilt. Maybe for your listeners' sake, just to distinguish between the two, in terms of criminal law, we have what we call the elements of a crime. In terms of the main count, which is murder, the requirement is obviously intention. Whilst in the case of the competent verdict, which is culpable homicide, it is sufficient for the state if they can prove 1% or more negligence on the side of Oscar Pistorius.
Looking at the bare facts, Oscar was there, the gun was there, the bullet holes were there, the 4 bullets that had been shot were there, Reeva's lifeless body was there, and Oscar admits that he did it. Whatever the outcome, would Oscar face a prison sentence anyway, just because of those facts? And is he trying to reduce that sentence? Or, by giving the version that he has, and within the rules of South African law, if his version is accepted, that it was a mistake and he feared for his life, could he walk free?
Right. Maybe a bit of history and a bit of background with regard to possible defences in our criminal law and procedure. First of all, correctly pointed out by yourself, most, if not 95% of all the elements that is required by a court to convict Oscar Pistorius is in one way or another either admitted or is not in dispute, precisely because we know where it happened, how it happened, when it happened, what was the result, etc., etc. So the only outstanding element in terms of our law that is still required to be proven by the state beyond reasonable doubt is obviously the reason why he did it, what went on in his mind. Now, once again, if we look at the main charge of murder, in order to secure a conviction of that count, the state must prove beyond reasonable doubt that he had the necessary intention to kill Reeva Steenkamp without any possible defense in law on his side. Then if we look at the competent verdict of culpable homicide, the court will put itself in the hands of Oscar Pistorius that night with all the surrounding circumstances, and then if the court decides that it would have deviated 1% or more from what happened, then obviously he was negligent and he will be convicted at least of culpable homicide. Now, all in all, yes, indeed, it's 2 different tests to be applied, the one subjective, the other one objective test.
His character and credibility have been on just as much trial as what he's actually been doing, and it sort of ties in maybe to what you've been saying. His defence lawyer, Barry Rue, he's tried to help him out a few times. The first time I think it was he objected to an ambush, the playing of a video in which Oscar was seen firing a gun at a watermelon. There were a couple of occasions as well. Not that many, and in fact the judges stepped in a couple of times as well. How are you rating Barry Rue's defence so far?
Well, remember, and maybe we should just stand for a moment still with that specific aspect. If he can show to the court that he was acting in self-defense, then obviously that is a total defense in our law against any charge whatsoever. But you are not allowed, even if you decide to call upon that defense, to overstep the boundaries. In other words, you must not use more aggression and or action than is absolutely necessary in the circumstances. In other words, if I can walk away from the immediate threat, then that is required by me. Now, getting to the barrier, obviously what's good for the goose is good for the gander. Now, because we've got an adversarial system in this country, we typically have two lawyers, litigants, fighting it out in the arena, which we call the court, in order to get the upper hand at some stage or another. Obviously, up till at least last week, we didn't have a taste of what is going to happen from the perspective of the prosecution, Llewelyn, because he didn't have the opportunity up to there to start his cross-examinations. And it was only then, when the gloves came off and Llewelyn had his opportunity, that we saw the true colors of the prosecution case. Now, make no mistake, the fangs came out, but you must remember, the outcome of this case probably turns on whether the judge finds that Oscar Pistorius is telling the truth or not.
Do you think that Barry Roux then has tried to paint Oscar maybe too white? He's gone maybe too much on him being a victim of crime, maybe too loving of Reeva. I mean, it seems so easy to be picked apart, almost to the point of making Pistorius' evidence look a little bit ridiculous. Should they have been more honest, do you think, about his character?
Yes, obviously that is a concern for the defense team. One would expect of all witnesses on the cross-examination to sometimes give and take, especially if there's no harm in any given stage, to actually confirm, yes, that is what I did. Yes, now that I've seen the light, or now that you put it that way, I accept responsibility, and I can safely say, but listen, yes, I can understand it might be wrong from the perspective of strict legal principles. However, in my mind, I did this and this and this for that and that reason.
I was wondering whether the fact that, I think it was about 3 occasions where Oscar appeared to blame his defence team, I was wondering whether that was a sign of some sort of friction between the two.
No.
No, it's not.
I won't say it was
or could it lead to friction?
No, it's not that unfamiliar. In actual fact, obviously, sometimes you would sit with a red face if you're on the wrong, so to speak. However, these are very senior practitioners, and I'm sure they are more than familiar with their counterpart attacking the witness and trying to shift blame basically onto the legal representatives. It's not uncommon to ask that kind of questions. Myself, have done it on numerous occasions. And typically what you try to do is not necessarily to blame your counterpart, but what you're trying to do is you would slowly like to chip in and to frustrate that typical emotional attachment that is in existence between the client and his legal counsel. And for example, on those 3 occasions that you've mentioned, Oscar Pistorius is not actually assisting his own case, because obviously that also looks bad in the eyes of the court. A better answer from Oscar Pistorius would have been, yes, we did discuss it. I didn't thought it was of such an importance, and obviously my counsel, neither did he. Otherwise, he surely would have mentioned it. But he is available in court, and I'm sure if you think it's necessary, he will in re-examination address those issues that were raised just now.
I don't want to argue with Mr. Now, my lady.
I'm so glad to remember that answer. I'll use it in future. You are not willing to concede anything. Oscar Pistorius will not take responsibility or concede anything. That's what you're doing to your own evidence.
Is that a question, my lady?
Yes, it's a question. Are you?
No, my lady, I have conceded on several occasions. I cannot agree with the statement that's put to me if I don't have a recollection of that event.
Both of them indicate that you fired through the sunroof. That is definitely a lie.
That is a lie, my lady.
Both of them independently would tell that lie.
They both took the stand. They both had different stories as to why it happened, as to where it happened. That story was fabricated, my lady. It's never happened. It was not the truth.
But it's a bad fabrication, because they never spoke to each other, it seems, because they've got different reasons why it happened, where it happened. It was a terrible fabrication between the two of them.
Although they said they haven't spoken to each other, they have been in contact with each other. They've been seen out at the same events.
Now, again, we have to blame your legal team. When they said they haven't had communication, Mr. Roo let slip. He never challenged them on that.
I don't remember if Mr. Roo challenged it or not.
He didn't. Take it from me. He will jump up if I say something wrong.
I'm just saying what I've heard, my lady. Maybe I didn't say that to Mr. Roo, but what I've heard is that they have had communication with each other. So that's all I can...
You're the one that said, in evidence, they said they didn't have communication. Am I right? You said that.
That is correct, my lady.
But you know that they had communication.
I beg your pardon.
But you know that they had communication.
I'm not saying I knew. I said I heard that they have communication.
Who told you?
I don't recall, my lady.
No. I apologize, my lady, for laughing. I won't do it again. But I was surprised by the answer.
That was a clip from court last week. Jerry Nell, they're getting into a little bit of trouble, actually, because the judge stepped in right after he apologised for laughing and said that it better not happen again. And she also then addressed the gallery and told them that it wasn't an entertainment programme. This was a court of law and should be treated with the respect that it was required. Although she didn't really say that, but that's pretty much the gist of her point. It's Monday Nights, Monday Matters, with me, Jason McCrossan. I'm talking to Dr. Llewelyn Curlewis, a prominent criminal law attorney in South Africa, also president of the Law Society of the Northern Provinces and the special legal advisor to Sky News. We're currently talking about the trial that's taking place in Pretoria in South Africa, that of Oscar Pistorius. We're going to take a quick music break. When we return, we're going to find out a little bit more about Oscar and the evidence he's been giving.
Listen to me.
It's Monday Night, Monday Matters. Very good evening. Thank you very much for staying with us here tonight. There are two court cases currently taking up the news headlines today. One is at the Old Bailey, where Andy Coulson gave evidence and said his affair with Rebecca Brooks was a mistake. The other big case is not in this country. It's over in South Africa. It's the murder trial of Oscar Pistorius. He's charged with killing his girlfriend Reeva Steenkamp almost a year ago. Now it was on the early hours of the 14th of February 2013. I'm talking to Llewelyn Curlewis, a criminal law attorney in South Africa and the special legal advisor to Sky News. Now, Llewelyn, I was watching the other day and Pistorius was being challenged by Jerry Nell on his house alarm. It was whether he definitely switched it off or probably switched it off. Anyway, under cross-examination, he basically broke down. He was sobbing. He started claiming to be tired. He stated that that was the reason he had made a mistake in his evidence, and it was at that sort of point that the judge intervened. She asked him a question. He then responded, but his answer was another statement. It wasn't the question that she'd actually asked him. So then she had to say to him, "That's not my question. The question is, are you too tired to proceed?" In fact, I tell you what, I've got a clip of that. Can we just play that clip, please?
I made a mistake, my lady, not because I'm tired. I made a mistake because I don't have a... Mr. Nell put to me that he asked me and I said that I switched the alarm off before I left my room.
Yes, but then can we accept that you haven't made this mistake because you're tired? Can we accept that?
Yeah, I can accept that, my lady.
No, can we accept that?
Yes, my lady.
Thank you. Yes, Mr. Nell?
The judge had previously said to him, so if you're tired and the reason you're making all these mistakes because you are tired, you must say so. Pistorius then had to say he wasn't tired and he could continue. When a judge is getting involved like that, referencing mistakes that you're making in your evidence, and then you have to contradict yourself from saying I'm tired to I'm not tired, I can continue. From a legal perspective, where does that put you?
Well, first of all, one must remember that Oscar Pistorius' life is at stake here. So at any given time, obviously the judge will assist the accused wherever it needs to be done so in order to make sure that justice prevails.
Will the judge have made a note of that in her notes?
Yeah, definitely. I do think the judge would have made a note of that. Make no mistake, everything is recorded. Everything is transcribed every day for the judge and the two assessors, and I'm sure they are studying the contents of what happened in court during the day every night to keep themselves abreast of the witness and the evidence that is in front of them. But I do agree that the judge basically also concurred with the observations made by Advocate Gerrie Nel. Now, that does not imply by all means that she already made up her mind. Remember, the totality of evidence must and will only be evaluated after the final arguments and addresses to court by the two legal representatives. She might or might not allow certain evidence to weigh heavier in favor of a successful prosecution than other evidence. Various evidence tend to have various weighing balance and material implications in a court case. For example, typically in our law we will expect viva voce evidence, which is oral evidence, to be of a better quality evidence than those contained in hearsay evidence that is allowed in court. Although hearsay evidence, as a general rule, once again is inadmissible in some instances, and even in this court case, in some instances there are exceptions to the rule and it was allowed in court. But one can be mindful of the fact that hearsay evidence, that even if, although it was allowed, will not have the same benefit and weight to be attached to it than the oral evidence that was forthcoming from the witnesses themselves. So it's difficult to determine at this stage who has the upper hand in the case. Make no mistake, where a court doubts the evidence, the advantage and the benefit of the doubt will always go to the accused.
It is Monday nights, Monday Matters. You're listening to me, Jason McCrossan. It's the 14th of April, and I'm currently in conversation with Llewelyn Curlewis. Now, he is a lawyer over in South Africa. He's also the legal advisor on Sky News at the moment. If you switch on Sky News during the day this week, you'll probably see his face. Now, Llewelyn, Oscar talked of his fear of violence. Now, in the UK, we don't tend to follow events in South Africa as much as we do in, say, America, where there seems to be some kind of shooting every other week. In terms of South Africa, which is a place that I've visited once before because I got friends over there who carry guns pretty much all the time, there is a fear of violence. But if everyone was that fearful, nobody would leave the house. But, I mean, you do hear of carjackings and house break-ins. Is that fear that Oscar spoke of something that South Africans can relate to? Or do you think when they hear him talk about things that have happened to him, they say, yeah, well, that's happened to me, but actually it didn't make me then go and shoot my partner or shoot my next door neighbour?
Right. Let's make no mistake, any kind of crime, regardless of the nature of it, and but especially obviously if it is of a serious nature, and I'm not talking about petty theft, I'm talking about break-ins, housebreaking, murders, and so on, hijackings and so on, are considered and should be considered as serious. Yes, South Africa has one of the, statistically wise, is considered to be one of the countries that has the highest crime rates. That does not imply that all of us are walking around 24/7 in the country with handguns, with security guards, and so on. It is like any developing state and country in the world. Wherever there is development, wherever there is money involved, wherever there is economic buzz, there is crime involved. And regardless of where you are in the world, there should always be a fear for crime if you participate in activities that is considered dangerous. in this specific instance, and that's why Harry Nel led that evidence in court. It is suggested, and it's thus far uncontested. So, in other words, it should be accepted as correct and as the truth. Oscar Pistorius had been staying at the time of this incident in a secure environment, in an upper-class neighborhood with 24-hour surveillance and protection. He slept with that is the evidence in court, with an open window. There's no burglar bars before the windows. There was no crime committed at his house or in any of his neighbors' house the last year or two that was reported at the police station. He even left his vehicle from time to time outside the premises. So if he was so concerned about his own safety, then surely he would have made each and every possible kind of behavior to protect his own life and that of Reeva Steenkamp. That didn't happen. So to get back to your question and to summarize the answer, yes, obviously we are concerned about crime in the country. However, it is not of such a nature that I have myself even considered walking around 24/7 with a firearm for personal protection. There's no need to do so. And even if you look at our tourism industry, you'll see that we've got huge numbers of foreigners, overseas, Europeans coming to our country and having a wonderful time. And that is indicative of the fact that it's of not such a serious nature that one can, as a general rule, generalize and say, but listen, to go to that country or to stay in your house at night, you are in for some kind of a crime that will be coming your way. That's purely nonsense. I can safely suggest to you that if ever you have the opportunity, please do not hesitate. Come and visit us again. You will have a bliss of a time and a wonderful time over here. But don't be stupid. Be mindful of the fact that there are criminals walking around, and if you are walking around late at night in some of these neighborhoods, then you should be concerned because you might be in for a hijacking or something like that. But that's the exception to the rule.
Because it's being led by a judge and there is no jury, does that mean you're more free to talk about the case than you would be if it was jury case? Because one of the things that we have over here is when there's a case going on, you've got to be very careful what you see, what you report, because if a jury finds out, if a jury reads something. Yeah. But you don't have that in that case.
Well, that's a very, very interesting question, and there's obviously two schools of thought about it. Remember, we do have the same common law background in the UK. First of all, we do have the sub judice rule also, but take into consideration that by now the comments that's made by myself, for example, and others alike, is based on evidence that's already before court. In other words, it's open to the public for scrutiny. We do not have a system where you are not allowed to talk about anything up to the stage that the final judgment or handed down, as long as you do not necessarily advance evidence that may be persuasive to the presiding judge. The mere fact that we don't have a jury is probably an advantage to even Mr. Pistorius himself, because we do expect our judge and the two assessors, which will ultimately have to decide on the issue, not to entertain themselves by looking on TV and perusing newspaper reports and so on, other than the official facts before them.
It is Monday nights, Monday Matters. It's me, Jason McCrossan. On the phone, all the way from South Africa, is Dr. Llewelyn Curlewis. We're talking about the trial of Oscar Pistorius. We're going to take a break. When we return, we're going to talk about the person who's making just as many column inches as Oscar Pistorius himself. Prosecutor Jerry Nell. It is Monday nights, Monday Matters. Another Monday Matters. nearly finished as well. But before we get to the Late Show with Dan Pope, I'm honoured to have our esteemed attorney, Dr. Curlewis. You can see his wonderful face.
Speak to me.
I'm going to. On Sky News.
We'll get into this quite a lot if we carry on, that you will blame anybody but yourself.
I don't agree, man.
Now you blame counsel. Mr. Roo, I know him, will not make those mistakes.
I didn't blame Mr. Roo, my lady.
You did. You see, he's not the only person in court. You have a whole team. Yesterday he told us about the team. There's a team in court. Everybody's listening to questions that Mr. Roo asks. Am I right?
That's correct, my lady. But
So everybody made a mistake.
It's not what I said, my lady.
It must be, because he was never challenged. Somebody made a mistake.
If Oscar Pistorius thought that he was the only star in town, he wasn't counting on Jerry Nell. Is he quite renowned in South Africa?
Yeah, he is renowned from a prosecutional perspective. He is a specialist in his field, and obviously he's considered by the National Prosecuting Authority as good enough to attend to a high-profile case of the nature of this. This is the first time around one of our criminal cases is published all over the world, so make no mistake, I do think there was a reason why they chose him. You remember that he was also involved in another high-profile case in our country when our police commissioner was standing trial, Jackie Selebe, and he successfully prosecuted him. And I think that might have been his claim to fame initially.
Wasn't it a bit more serious for Jerry as well? Didn't that prosecutor get him arrested?
Yeah, correct. But obviously that's been sorted out, and ultimately he was absolved of any wrongdoing on his side. And I think it was maybe a manipulative move by Jackie Selebe at the stage to try and disorientate the state's case and even Gerry Nell.
Do you know him personally?
We more or less know each other, especially because we are predominantly practicing in the same city. So I do know Gerry Nell, and I do know Barry Roo as well. So.
Yeah. So just looking at the personalities, Barry Roo, I don't know, he sort of comes across as being a bit softer, a little more cuddly. You'd probably see him as maybe your grandfather, nice. Whereas Jerry Nell, well, he's the attack dog, isn't he? If he's got hold of your leg, he ain't letting go. Yeah,
I must tell you that there's a split jury on this one. This morning I read in one of our newspapers, for example, that Gerry Nell is a soft-hearted person considered by the children that he trains in the evenings when he trains them wrestling lessons and so on.
Right.
So at least a lot of children out here considers him as a soft-hearted person. Obviously, Barry Roo also does a lot of civil litigation, whilst Gerry Nell is only involved predominantly in criminal law and litigation because he's working for the National Prosecuting Authority, and maybe that's a difference as well between them, because in civil litigation you typically don't always have an accused that you have to confront. You have an opponent, and one is much more lenient towards an opponent, which is also a legal expert from an ethical point of view, for example. However, one's case is only as strong as the evidence and the version of your client. So to say the one has the upper hand or the one is better than the other one, that's obviously an unfair question or allegation, because next time around Barry Roo might have a very, very strong case, or he might have a poor case, and then your opponent, even if it's a much junior litigant, for example, might have the upper hand. So that's unfortunately or fortunately the way the law works. Sometimes you win, sometimes you lose. There's a lot of cases where Gerry Nell did not secure a conviction in criminal cases, whilst there are a lot of cases where Barry Roo successfully defended these clients. And also, I'm sure if one asks him, he will be the first one to tell you that there's a lot of cases that he, in quotation mark, lost ultimately.
I read that Jerry Nell has been reported to something, the Human Rights Commission, because of his aggression when interviewing. Is that just bluff and bluster, really? Is it even serious?
Yeah, no, he was actually reported a day or two ago at the Human Rights Commission for apparently badgering the witness and calling him a liar, and that was the allegation made against him at the Human Rights Commission. But let's make no mistake, that is absurd. In terms of our Criminal Procedure Act, one is entitled to cross-examine, and if one has to be blunt, and even if one has to come over as insensitive and call a spade, then you are protected by the court procedure as such. Anything and everything you say in court is, for most part of it, especially in a criminal case, considered to be out in the open, and you are allowed to cross-examine on that basis. So I don't think anything will come from that. The judge is there ultimately to protect even the accused, where the prosecuting counsel is transgressing court rules, ethics, or even overstepping his boundaries and badgering an accused per se.
He often referred to how he was acting purely in Reeva's defence, that he was telling his story and wanted to tell his story out of respect for not only himself but that of Reeva and her memory. I was just thinking, if he's found guilty, he'll have pretty much have gone as low as you could possibly go by saying that.
Sure.
But is that just the way these things go?
Well, yeah. Obviously, if he is convicted and the court decides and found that his version is totally untruthful and should be disregarded in totality, then obviously that proves precisely what Gerry Nel have accused him of, and that's being that he's a liar. Now, Gerry Nel will then argue when sentencing is considered that Oscar Pistorius did precisely the opposite by making those kind of comments in court, that he dishonoured her to such an extent that he actually tried to use her indirectly to advance his defence, because that is ultimately then what it will boil down to. And that might have an aggravating aspect attached to it, which obviously Gerry Nel will ask the court to find, which will have an impact on the sentence that will ultimately be imposed. So, but we also take into consideration, Judge Thukhuzile Masipa at some stage mentioned that she to a large degree do see that there's emotional truth in the sobbing that was forthcoming by Oscar Pistorius. That does not say in itself that she believes his version, but at least the tears that flew that came out in court seems to be on face value that there might be some truth and emotional truthfulness in it.
When do we think this trial will reach its conclusion?
We do have the Easter weekend coming up now in 4 days from now, which will obviously necessitate a postponement taking place, at least on Thursday. So by Thursday, if the defence did not close its case by then the matter will stand over until next week for further consideration. But fortunately, we are already over the halfway mark. So let's hold thumbs that Barry Roo can try to accommodate everybody out there, and let's finalise the matter before the end of the term. But I do not think we will have the final call on this one before later the year. Remember, the judge and the assessors will probably also ask an adjournment for a month or so to consider all the evidence before they give their judgment. I don't think we will expect an tempore judgment right there and then after all the evidence has been led. They will ask for the adjournment to consider. And then, depending on the outcome, if he's discharged and acquitted on all the charges, that's the end of the story. However, if not, then we will be in for the second round, and that is the mitigating and aggravating circumstances that will require evidence to be led in court before a sentence is imposed. And after that, we might not have seen the last of it as well, because depending on what then happens, one of the two parties might be inclined to seek an appeal on either the judgment and the rulings of the court, or even on the sentencing, whether it's the state or whether it's the defence. So we will probably have to chat another time again, but that won't be in the foreseeable future.
And when are you next due to be on Sky News? You're one of their legal advisors. Do you know? Will you be on this week?
Yes, no, I will be back in office, so to speak, tomorrow morning. So me and Jeremy Thompson and Alex Crawford will have a chat, probably at 9:30 tomorrow morning when the court case kicks off again. And during the course of the day, I will have a more or less an opportunity to speak to your listeners on television, probably every half hour or hour on the hour. So hopefully your listeners out there or your viewers haven't seen enough of me by now, but that's the way things work.
Llewelyn, thank you very much indeed for your time. I look forward to seeing you tomorrow.
It was a pleasure speaking to you, and have a good night.
Good night. Thank you.
Don't forget, if you want to keep up to date on everything Sittingbourne, check out the 106.9 SFM website at www.sfmradio.com. 100% local radio for Sittingbourne. 106.9 SFM.